two things happened. One was I had a person who worked for me who said, when will we know we've succeeded? And what she meant was, how many laws do we have to get adopted for us to say we're successful at what we do? I didn't realize that's what she was asking. I thought she was looking at our mission statement, which was to work for justice that reflected biblical principles of justice and righteousness. So that was the big picture question. At about the same time, I remembered something that Sharif Bassioni, who was my law professor at DePaul, had said as kind of a throwaway comment in criminal law class, which was that we didn't always have criminal law. That started when the states began centralized government began. Kings wanted control over the local barons, the local courts, and so they decreed their piece over all of their piece of territory. And anybody who committed a crime was committing that now not just against the victim, but it was now a crime. The king was the victim of what had taken place because they were violating the king's peace. And they used that then as a jurisdictional ploy against both the church, which had its own legal system, and against the local barons who had their legal systems. And it was a way of making people come to the king's system. Now that was very illuminating because I realized this was a political move. This wasn't a great, it's not like we've always had criminal law or that it was a great criminological insight that part of the problem that we're having here is that we're not focused on the law breaking. It was simply a move that worked and continued and became profitable to the king. It initially ordered restitution, then began saying, this is taking me time and energy, and so kept it as fines, and then moved on from there. So piecing together the absence of the victim that had happened at that point with the question of what are we really after? What is success for us? Made me realize I was seeing it happen. We were seeing it happen at the local level, the individual level, in the victim offender mediation meetings, the dialogue that was taking place. That victims and offenders together were identifying justice and injustice in ways that didn't happen when it was just the offender in court. But I realized that it was not just an individual thing; it was a systemic thing. That we had a major problem with the criminal justice system because there was no victim present, saying, "I'm the person who's been hurt. I have these interests, and I want these interests addressed in this context." The victim movement had made a lot of progress on this happened to us, we need information about what happened. We need to be able to make eventually a statement at sentencing. But implicit in all of that was the prosecutors representing our interests. We don't really have a right to be there. We would like to be able to sit in the courtroom and listen to the whole thing and not be excluded because we're a potential witness. But those were important, those were critical, but it seemed to me that they didn't get to the core, which was this happened to the victim, so the victim ought to be there and ought to have a legal interest. We received a grant that allowed us to bring together a group of people, and over a 3-year period we tried to articulate what is restorative justice and then what are the basic principles that apply. What are the kind of the key characteristics? If we could say in general terms, these three things, whatever, have changed, then we would have moved in a more restorative direction from a policy perspective. And then what are practices that would come out of that? What are some actual programs that we could support? And it was a very interesting process. It was a very difficult process, but energizing. I mean, it was interesting because you're sort of making up something. I remember in the middle of that going to a conference, Howard Zehr was speaking, and he started talking about co-option. Everybody else was speaking, I can't get a case referred to me by the probation. And Howard, who had seen some cases referred by probation, now probation was interested and the prosecutors were interested, was talking about co-option. I was thinking, co-option? We're not even existing. And here you are worried about co-option already. But and Howard is ahead of his time in many respects, and he was then too. So, but it was interesting. But nobody at that time thought that this was, I mean, we thought it should happen, but didn't think anything was going to, we just didn't expect much. We just wanted funding for Indiana for another 3 years so that these programs could continue to work. We identified 4 changes that we thought should take place in every community, and if these 4 changes took place, then we would have moved in a restorative direction. 2 of them were community building, community organizing activities. The other two were things that would have to be done by the legislature. They required legislative change, so they were lobbying type activities. We were actually better at lobbying than we were at community organizing, as it turned out. But Prison Fellowship is a prison ministry that's faith-based. And so we said, well, one thing is there should be a faith-based ministry to victims of crime, so that when somebody is hurt, then there should be people who can help do crime scene cleanup. They can repair the door, they can bring food, they can be a listening ear, they can explain the court process. Some of that was already happening in victim witness programs, but generally they were limited to people who had been victims of very serious violent crimes, or were survivors of homicide, and it was for financial reasons. And our thought was, if we could organize the faith community to respond. And the name of the program was Neighbors Who Care, which was taken from the story of the Good Samaritan, who was the man who stopped to help a person who had been beaten and robbed. The religious people walked past for whatever reason, but this heretic stopped, and he was the one that took care of him. And Jesus said, that is the person who is the neighbor. So we said, okay, well, let's organize people to be neighbors in this response. It was an idea actually we had gotten from people in the victim movement who said they didn't understand why churches were so interested in prisoners and not in victims. The second thing that we thought, if in faith communities in a community there was an ability and a willingness to mediate victim offender meetings, then there would be an alternative to which those people could turn if they wanted to do that as opposed to the court process. And we didn't mean as an entirely independent structure, but if there were that capability available to the justice system and victims were wanting that, offenders were wanting that, then there would be something available. Those were the two community-based responses. The two that were legislative, one was that people who were not guilty of violent crimes, or who had not committed violent crimes, should not be sent to prison. It was sort of a negative. Don't send those people to prison. Instead, require them to pay restitution, and then whatever other incapacitative or rehabilitative dimensions to a sentence that you want to add to that. But the key focus for offenders should be that they pay restitution to the victim. So obviously, don't lock up somebody who's not a danger. And then there should be work programs for them while they're in prison, so that for those that do go, so that they can pay. So the idea was, if restitution is the key focus, which it should be if we're trying to make things right for the victim, everything else needs to come in kind of secondary and be fitted around that. The second legislative change was that victims should have the right to come into court with a lawyer. They should have a legal interest that's articulated and defined, and that legal interest should be to assert their right to anything that would prevent them from further harm. So if there were safety concerns they had with bail or with a sentencing or something like that, then they should be able to come in and speak to that, offer evidence and argue. And then second, their right to restitution for the harm that they received. And again, they could come in at sentencing and argue for restitution and make their case and that sort of thing. It would not be something they'd be required to do, but the idea was give them two options. They can participate in a victim offender meeting, or they can participate in court. That's never been adopted in the United States, but it is adapted from what happens in Europe, in France and Germany and other places. And typically it's a right that victims have but that they don't exercise, but it is available. And they end up doing something that's similar to our victim impact statements, but they've chosen to do that as opposed to the more aggressive stance, rather than this is as much as you're going to get. We don't quite know what the judge will do with this, but go ahead and make your statement. We thought they should be able to make a statement, and there should be a reason for that, and the judge should have to consider that in imposing the sentence. So that gave us things to work on from a lobbying perspective and from a community organizing perspective.